This morning at 9:45 a.m., the atmosphere in the courtroom changed. I felt it. Everyone present felt it. We were 90 minutes into testimony behind closed doors when the defense team realized their strategy had collapsed. The reports you're seeing today claim the defendant broke down. And knowing how the media operates, you might dismiss that as sensational headlines. But I was there, and I need you to understand this. What happened was not a common emotional outburst. It wasn't tears, it wasn't shouting, it was something far more significant for a prosecutor to witness. It was a total and calculated loss of control when the former president faced the only witness he could not intimidate, his own daughter. I have prosecuted heads of state and organized crime figures. I know the look of a defendant who realizes the walls are closing in. He didn't scream. He simply crumpled. Let me tell you why. It wasn't because of the thousands of emails we've already entered into evidence. It wasn't because of the surveillance tapes from the Florida property. It was because of one single specific item the witness identified under oath, a red folder. Why did this folder cause the defendant to slump in his chair and whisper frantically to his lawyers when boxes of classified documents didn't faze him? Because that red folder proves the one thing that turns a case of mishandling documents into a prison sentence: intent. I'm going to explain to you exactly what she said, line by line. I'm going to describe the documents she identified so you can visualize them as clearly as if you were holding them, because the words themselves are the evidence. Let me take you inside the room. When the witness took the stand, there was absolute silence. You could hear the hum of the air conditioning. The defense expected her to do what family members usually do in these situations: plead the fifth or rely on a sudden loss of memory. I don't recall. I don't remember. I'm not sure. That's what's expected. But she didn't follow that script. She didn't look at her father. She looked at the prosecutor. And when asked about moving boxes to the Bedminster property in June 2024, she said one word: yes. I want you to visualize the timeline she just presented. This wasn't about vague memories. This was about specific instructions given on a specific Tuesday in June. Listen to the precision of this answer. I'll break down the three key questions that dismantled the defense. Question 1. Did you receive instructions to move specific materials prior to the FBI raid? Her answer: I was told to ensure the personal correspondence was separated from the business records. That sounds pretty innocent, right? Then came question 2. Who gave that order? Her answer: the defendant. And finally, the question that took everyone's breath away. Question 3. You saw what was inside the boxes marked personal. In my experience, vagueness is a shield. Today, she abandoned that shield. She described the contents with photographic detail. She didn't say papers. She described government markings. She described foreign intelligence briefings. And she described that red folder. I want you to understand the weight of this admission. It completely eliminates the possibility of credible denial. It destroys the rogue employee argument. The defense has spent 18 months arguing that low-level aides moved these boxes without the former president's knowledge. They claimed he was too busy running the country or running a campaign to know what was being packed. The witness just testified that he didn't just know, he ordered it. If you could have seen the defense attorneys' faces at that moment, you'd have seen them go completely pale. They knew what I knew. You can't cross-examine a family member and call her a liar without alienating the jury forever. She confirmed the order. She confirmed the knowledge, and she confirmed the cover-up. That's what she said. Now let me show you how he reacted, because the behavior I observed tells a story just as condemning as the testimony itself. I observed the hands. I observed the eyes. That's where the truth is revealed. When you hear reports the defendant broke down, you might imagine tears. But in a legal context, a breakdown is the collapse of a brush strategy. It's the moment the defendant realizes the mask no longer fits. During the New York civil fraud trials, and even during the early procedural hearings of this case, the former president maintained a posture of defiance, chin up, leaning back, staring intently at the stand. He was projecting strength. He was performing for the cameras even when they weren't allowed inside. Today, that bravado evaporated as the witness described the red folder. His posture physically changed. He slumped forward. He began whispering frantically to his lead attorney. Not angry whispers, but urgent, panicked questions. I've seen this reaction in cartel bosses and corporate fraudsters. It's the moment of realization. The color drained from his face, not from sadness, but from calculation. The calculation no longer worked. He realized loyalty has a limit, and that limit is perjury. This was not the reaction of an innocent man confused by a lie. An innocent man gets angry when falsely accused. He shakes his head, looks at the jury in disbelief. The defendant did not look at the jury. He looked at the table. He could not make eye contact with the witness stand. That brings us back to what I mentioned at the beginning, the red folder. Why did this specific item provoke such an intense reaction? Here's what I can tell you from the evidence record. The red folder contained documents he had personally claimed in a signed 2022 affidavit to have returned to the National Archives. He put his signature on a legal document stating this folder had already been returned. His daughter just placed that folder 2 years later, literally in his hands. That's why he slumped. He wasn't just hearing testimony. He was hearing a perjury charge forming at that moment. He was hearing obstruction of justice charges piling up. This is what happens when political propaganda collides with legal reality. But there's another question here. Why now? Why did the witness choose to speak today after defending her father for so long? History teaches us that the innermost circles are the first to break when the pressure becomes existential. I've studied the mafia trials of the 80s. I've built cases against massive corporate fraud networks like Enron and WorldCom. The pattern is identical. In the Southern District of New York, we had a saying, blood may be thicker than water, but it's not thicker than a federal indictment. When the subpoena arrives, the family dinner changes. Prosecutors use a strategy called the pressure cooker. We don't try to get strangers to talk. First, we apply pressure to those who have the most to lose. The witness isn't just a daughter. She's a businesswoman. She has assets. She has a reputation she's trying to rebuild, and she has her own legal exposure. If she lied on the stand to protect the defendant, she would be committing a felony. She would be risking prison time herself. This isn't betrayal. In the eyes of the law, this is self-preservation. We saw this with the Gambino crime family. We saw it in the 90s insider trading scandals. The patriarch trusts the silence of the children, assuming the family bond is stronger than the penal code. It rarely is. When the witness entered that courtroom, she made a calculation. She could protect the defendant and destroy herself, or she could tell the truth and survive. I want you to consider the psychology here. She knows the evidence we have. She knows we have the surveillance tapes. She knows we have the flight logs. If she denies seeing the boxes and we play a tape showing her standing next to them, she goes to prison. It's that simple. Her testimony wasn't an act of sudden moral awakening. It was survival instinct. The defense knows this. That's why they didn't cross-examine her aggressively. You can't attack a witness for telling the truth when you know the prosecution has the evidence to back it up. They let her step down without questioning her. That silence from the defense said everything. Now back to that red folder. Because self-preservation explains why she spoke, but the content as of that folder explains why it's fatal for the defense. I want to be precise about what the red folder really represents. Some of you might be thinking, it's just paper. Does it really matter if it was in a red folder or a cardboard box? Yes, it matters. In fact, it's what defines the case in criminal law. Proving the act is easy. We know he took the documents. That's the actus reus, the guilty act. But to get a conviction under the Espionage Act, we have to prove the mens rea, the guilty mind. We have to prove he knew what he was doing was wrong and did it anyway. This folder is the definitive evidence, not because of what it contains, but because of where it was found and what it contained. According to the witness's description, this folder didn't just contain standard typed government reports. It contained handwritten notes. Notes written by the former president himself in the margins of classified intelligence assessments. Why is this fatal? Because you can't claim you accidentally grabbed a folder and I wrote in it. You can't claim you didn't know it was classified if your own handwriting is next to the top secret stamp. The witness testified that she saw him reviewing this specific folder at the New Jersey property, a location not authorized to hold these secrets. This proves he was actively using these stolen documents. He wasn't just storing them, he was using them. I've held similar evidence in my hands during war crimes tribunals. When you find a commander's handwriting on an illegal order, the ignorance defense disappears. He claimed he didn't have it. She testified she saw him holding it. In 30 years as a prosecutor, I've learned it's always the cover-up that gets you. If he had simply returned the documents when asked, we might not be here. But he lied. He signed an affidavit saying this folder had been returned. Let me define mens rea in this context. It's the difference between a mistake and a crime. Taking a folder home is a mistake. Lying about it, hiding it, and then having a key family member testify you were reading it after the subpoena deadline, that's a crime. So where does this leave us? We are witnessing a constitutional stress test unparalleled in our history. It's 2026. We have a sitting president now directly implicated by his own family member in a felony involving national security. The Constitution is not a suicide pact. It was designed to withstand pressure, but it wasn't designed for this. If this testimony holds, and the evidence suggests it will, we are in uncharted territory. The Justice Department has a long-standing policy against indicting a sitting president, but that policy is a memorandum, not a law. It has never been tested against facts like these. I took an oath to defend this system. That oath doesn't expire. And what I see right now is a system in critical condition. There are those who say it doesn't matter, he won the election, the people decided. But facts exist forever. The law doesn't bend simply because an election occurred. If a daughter can't protect a president from the truth, neither can the office. Consider the precedent we're setting. If we allow a president to steal national defense information, lie about it, and suborn perjury to cover it up, we have effectively legalized espionage for the executive branch. This testimony is on the record. It cannot be deleted with a post. It cannot be pardoned. It is now part of the historical record of this administration. Here's the hypothetical scenario we must face. What if the special counsel moves for an indictment based on this new testimony? We could see an impeachment inquiry launched not by political opposition, but by forensic evidence provided by the family itself. I want you to understand the gravity of this. This isn't about politics. It's about whether nuclear codes, our intelligence assets, and military plans are secure. If the person who has them treats them like personal souvenirs and lies to the FBI about them, the danger is real. I have seen how fragile democracies can be. I have seen systems collapse when the powerful are allowed to operate outside the rules. We are closer to that edge than many people realize. But the fact that this testimony happened, the fact that a witness sat in that chair and told the truth despite immense pressure to lie, gives me hope. It shows that the truth has a way of coming out. So where does this leave us? It leaves us with a decision. Do we accept the evidence or do we look the other way? Today we saw the facade crack. Tomorrow we will see what's behind it. Justice moves slowly, but it arrives. I know you feel this process has taken forever. I know you feel there are endless delays and appeals, but what happened in that courtroom this morning proves the system still works. The collapse of the defense strategy wasn't just a man losing his composure. It was the reality of the law finally breaking the bubble of power. Justice is not a sprint. It's a marathon, and we are approaching the finish line. No one is above the law, not the defendant, not his family, not today, not ever. The system works when we bear witness. It works when we refuse to let the noise drown out the facts. The witness just exposed the documents, but that's nothing compared to the move his wife just made. The Supreme Court just rejected the final appeal, and she is looking for an exit strategy. Yeah,